and welcome to DFDL's webinar about share pledge enforcement and distressed M&A. I'm Nishant Choudhary, and I will be moderating this webinar. We are DFDL, for those people who do not know about us. We are a Southeast Asian firm with presence in most of the countries of ASEAN, with the exception of Brunei. In Myanmar, we have been since 1996, and I have the privilege of heading the operations in Myanmar. So thank you, everybody, for joining. And I hope you will have a productive session and you will have many takeaways from it. So since the coup, Myanmar has witnessed several liquidations and disinvestments as businesses reassesses their options. The decision to wind up a company or sell it to a third party is purely a commercial issue, but carries distinct consequences. Winding up permanently ends the company's existence, impacting the employees, the suppliers, while this investment on the other side allows the business continuity under a new ownership. Procedurally, winding up can be more complex and costly, often leading to complete loss of shareholders' value. In contrast, a disinvestment, if the company remains profitable, preserves value, sustains operation, benefiting both the economy and the livelihood. Given the current landscape, an investor who sees potential in a business may find value in acquiring it, provided they conduct thorough due diligence and clear any sanctions or reputational risks. Negotiating fair pricing and ensuring operational continuity can secure jobs, maintain supply chain, and offer long-term returns. This presentation outlines a fast-track approach for investors seeking to navigate disinvestment efficiently while ensuring compliance and sustainability. The presentation covers Myanmar legal and tax theory and practice regarding the acquisition of a distressed business and subsequent sale of the business to a buyer. Presentation is based on sample transaction involving Myanmar and foreign elements. The transaction sampled here involves third-party security over shares in a Myanmar foreign joint venture owned by Myanmar entity in connection with a loan taken by Myanmar borrower and credit enhanced by a guarantee from the foreign shareholder. Allow me to introduce you to my panel. So we have Diberjohn, who's our tax partner, focuses on Myanmar tax consideration. We have Surath Bhattacharjee, who is our senior advisor, focuses on Myanmar issues. And we also have Rohan Bishayee, who's also a long practicing Myanmar advisor and dedicates his time for Myanmar legal issues. So we would, Vati, can we go to the structure? So before we go into the structure of the seminar or webinar, there's some housekeeping aspects. So we have Q&A activated. You can type your questions there at the Q&A box, which we will attempt to answer at the end of the presentation. So taking into consideration the structure, in the present case, there is a company X operating in Myanmar, has a joint shareholding structure. Shareholder A, who's a local shareholder, holds, say, approximately 65% of shares. And shareholder B, who's a foreign shareholder, say, holds 35%. To finance the operations of Company X secures a loan from Bank B in Myanmar. The loan is guaranteed by the group holding company of shareholder B, which is the foreign shareholder. As a collateral for this guarantee, shareholder A, that is the local shareholder, pledges its 65% shares in the company X to the group holding company. Upon defaulting on its loan obligations, bank enforces the guarantee, requiring group holding company to settle the debt. After doing so, group holding company seeks to enforce the pledge of shares against the shareholder A's 65% stake in company X. Pursuant to the enforcement process, group holding company also intends to sell the pledge shares to the new buyer. So with that in mind, I would quickly jump into and discuss with our panelists who are excited to put forward their views as well. So with that in mind, may I call upon Surath? And Surath, I think so, to set the tone, it would be important to probably give the flavor as to what are some ancillary documents that you must get pre-signed from a pledgeor.
Right.
Apologies, Surath. My question, I jumped a bit. So my question would be to give a flavor in, why don't you just primarily just introduce what a pledge of shares in Myanmar is, and then we'll take the forward questions.
Sure. Thanks, Nishant, for this. Hi, everyone. I am Surath, an advisor at DFDL, supporting the Myanmar business unit from Bangkok. Thank you very much for joining us today. While many of you would be familiar with the basic concept of pledges, I'll just take a few minutes of your time to briefly recap them for everyone's benefit. So in Myanmar, the legal basis for share pledges is drawn from the Myanmar Contract Act of 1872, which which defines a pledge as the delivery of goods as security for a loan. Now, the pledge may secure a loan from a bank, or it may not be tethered to a financial institution loan at all, as in this case, where the pledge actually secures the repayment of the amounts the group holdco will pay to the bank upon enforcement of the guarantee. Now, in terms of the form of the pledge, it can take the form of an agreement or a deed, depending on the consideration requirement. Now, in case of a deed, there would be some minor drafting additions as well that would indicate that the document is being signed and delivered as a deed. This is in the normal course of things in Myanmar, and I'm sure in the other common law jurisdictions as well. So the signing formalities would differ based on whether the agreement, whether the pledge is signed in the form of an agreement or a deed. Importantly, in this aspect, it is it's notable that there is a provision in the Myanmar Companies Law. This is the nodal act which regulates company registration, incorporation, and registration in Myanmar, which allows a company to sign in ways other than those prescribed under the MCL. So just to back up a bit, if the relevant section of the MCL would mention that in case of a deed, 2 directors must sign, or a director and a company secretary must sign, you can, via a board resolution, indicate that there would be only 1 authorized director to sign the deed. That's also doable. But in most cases, we observe that a deed is signed by 2 directors. Now, a typical pledge agreement, a typical pledge document, let's put it this way, it contains, among other clauses, a covenant to pay. Then it contains the obligations on the pledgeor to hand over certain documents to the pledgee on the date of signing of the share pledge agreement. Then you'll have representations and warranties from both the pledgeor and the company, the target company in this case. And you would have provisions on enforcement, and most importantly, a schedule of ancillary documents which you need to sign pre-sign and submit to the pledgee as part of the submission requirements. Now, coming to the documents that you must hand over, some of those documents are original share certificates, signed and undated share transfer form. Then you have the director resignation forms and board resolution and so on. Now, pledgor is also responsible for stamping the pledge document by paying appropriate stamp duty. More on this would be dealt by our tax partner, who will present on this aspect in detail a bit later on. And importantly, considering that the nature of the document is a pledge and a mortgage, which is a hybrid form, there is a requirement to have it to register it with as well. So once you agree to the contents of a pledge agreement and you sign it, you submit the ancillary documents as required. You must also get it stamped. You must also register that document with TICA. I think with that, I would conclude the basic aspects of pledge in Myanmar. Nishant.
Thank you, Surath. And when you talk about pledge in general, and in particular about share pledge, I presume it's a hybrid document, as you've enunciated through so many documents. But what are some provisions, say, of the shareholder agreement, do we need to look into to assess whether the pledge is contractually valid? And there are no restrictions in the joint venture to that effect.
Thanks, Nishant. So this is mostly a pre-pledge, diligence kind of a consideration. So when a pledgee is entering into a pledge, prior to that, there are certain considerations. So in case of a situation, in case the pledgor is a company, is a shareholder in a company having multiple shareholders. So there are certain considerations that the pledgee would have to, take note of before entering. So what we typically see is there are some clauses in shareholder agreements which restrict the pledgor from transferring the shares in any way within a certain period of time after entering into the SHA. Now, if you see a sample clause that we have put on the slide, this particular clause, it states that the pledgor, the particular shareholder, the parties to the shareholding agreement cannot transfer more than 20% of any within before the expiry of the lockup period. So in such circumstances, it is important to note that the pledgor would have to obtain a certain contractual consents already from the existing shareholding relationship before it can pledge. Now, you can say that the pledgee can, of course, protect itself from these risks and other legacy non-compliance issues by having such relevant, representations, warranties, and covenants. But I think for good office order, it would not harm to, review these type of documents and negotiate how to best move about and for the pledgor to obtain these approvals prior to, entering into the share pledge. Because after you enter into the share pledge and all of these issues are found out, then it leads to protracted discussions, negotiations, and it leads to subsequent delays and changes in commercial goals, etc. So it's better to avoid such instances and be mindful of these particular clauses in the SHS. And also one important clause is, there could be some matters which are reserved for decision by the board. Now, the board in a joint venture situation would consist of directors from either side. So, and you cannot take a unilateral decision to pledge the shares without getting the consent from the other director. So all these, contractual issues should be ironed out first before the pledge agreement is entered into, albeit there are protections in the pledge agreement itself.
Makes total sense, because once a company is in or when there is a distress situation, then obviously the support diminishes from the either party. And that does make sense that you're able to have these pre-executed, undated documents in place. And for instance, the clause which you have referred, a specific waiver to that effect is pre-executed and taken as an ancillary document to the pledge itself. So that totally makes sense. And while you said that, tax element, I understand Diber will touch upon, but very quickly, what is the ballpark amount? Is it an ad valorem? Is it a fixed amount on a share pledge?
Yeah, so basically, it's an ad valorem amount which is mentioned in the Schedule 1 to the Stamp Act. It states that the amount of stamp duty payable on a share pledge agreement is 0.0065% of the loan amount. It's important to note that it's not the value of the shares, but it's the loan amount. And stamp authorities typically review this particular, when assessing or adjudicating the rate of stamp duty applicable on a pledge deed, they take into consideration this aspect predominantly. Gone are those days when companies were able to explain to the stamp officer that this is a hybrid document and
Yes.
not found. This should fall under Section 5D, which stipulates a stamp duty of 300 kyat. Those were the halcyon days of explaining the situation to the stamp officer. But now mostly they would prefer to get 0.0065. I think this would be explained better by Diber, who is more.
Certainly, and it's a good point that there were in the initial days a fair bit of ambiguity and different interpretations. But I think the practice today, as it stands, is well settled, and ad valorem amount will be applicable as enunciated in the stamp duty Schedule 1. Good point. And I believe we have already discussed about the ancillary documents, so I'm not going to go ahead and touch upon that any further. What happens if the pledgor does not comply with the contractual requirements to update an ancillary document in the pledge? I'll give you an example. For instance, there is a director resignation document which you take in order to control the board, and in between there is, and we all know that pledge agreement has a clause that if you're changing a director, you need to refurbish those director resignation documents or other similar documents. And so what if they fail to do that?
So I think it's important to understand the responsibility here, whose responsibility it is to update these documents. So technically under share pledge agreements, share pledge documents, it is the pledgeor's responsibility to update these ancillary documents such as the board resolutions, the resignation letter, the letter of authority authorizing the company to date the resignation letter, and so on. Now, as you have rightly pointed out, there are clauses in the share pledge, in typical share pledge documents which require pledgors to, sometimes take prior approval of the lender before making any changes to the management, changes in the directors, etc., authorized signatories. And there are certain other instances where the pledgors are required to notify as well. So these have distinct repercussions if you are not distinct repercussions for both the pledgor and the pledgee if this is not done with respect to the pledgeor's responsibility, and if this is not monitored with respect to the creditors or the pledgee's responsibility. Now,
thank you, Surath. And I understand it's very important that parties continue monitoring this, and that is the very basic basis which then becomes an efficient enforcement vis-a-vis non-efficient enforcement. Good to know that. And another question would be, what is the primary, we're giving that key to the people here who are listening to us. What is the primary ancillary document that you can use to get control of the company at the enforcement time? And this is keeping in mind that maybe there has not been an updating of other relevant ancillary documents, so on and so forth.
So the primary document in this, in any share pledge enforcement, would be the irrevocable proxy and power of attorney, which is signed at the time of entry into the share pledge, but not dated at that point of time. This is precisely for the reason that this is pre-signed. This is a pre-signed document. It's pre-signed precisely for the reason to abate any risk at the time of enforcement when the directors or the authorized signatory might not cooperate with you. So this particular document, it gives a whole host of powers to the pledgee to act on behalf of the defaulting pledger, as if the pledgee was in the position of the pledger from the get-go. So some of the functions that, some of the powers that the pledgee can act pursuant to this particular document is it can vote, it can act and take decisions regarding the pledged shares, including filling up the share transfer forms. It can elect directors and signing resolutions. It can make legal declarations related to the pledged shares, etc., transfer or share, sell the pledged shares and manage the proceeds as deemed appropriate. So largely a broad gamut of powers that this particular document offers to the pledgee at any time after the enforcement is triggered.
Understand. So it's more of a master key, as we can coin that as.
Absolutely.
Great. Thanks. And I mean, can we really sell directly without foreclosing a share pledge?
Yeah, so again, going back to the relevant provision of the Myanmar Contract Act on pledges, which regulates it. So that particular section, section 172 of the Contract Act, says that you can the pledgee has the right to sue the pledgor for the debt amount, or it can sell the collateral. Now, contractually, parties can agree that the pledgor would transfer the shares in favor of the pledgee. Now, why we raise this topic, whether you can force, foreclose it or confiscate the shares versus sell the shares. Now, it has to be remembered that the case study that we are sampling here involved a situation where the particular pledgee wanted to take possession over the shares and bring the company under the shareholding of the offshore group company. That's the first course of action that they wanted to do. And at that point of time, they did not have a buyer in place. So in the event that you already have a buyer in place, might as well go ahead and straight sell by auction sale. So there is nothing stopping stopping the pledgee as far as the law is concerned to directly sell the shares to a third party. But
Understand.
yeah. The sale, the transfer and the sale would obviously be subject to taking relevant regulatory approvals and contractual consents, which my colleague Rohan would deal with after.
Correct. Yeah. Thanks, Surath. And I'm a bit mindful of time. And so because we have to cover a lot from here on. And from an enforcement perspective, the event of default perspective, like where the cure period has lapsed, what will be the day one for an enforcement?
Yeah, so I think it's important to segregate this on the basis of the facts that we are discussing, because this is not a typical, bank loan enforcement. It's not tethered to a bank loan enforcement. This is something which is a shared pledge enforcement as a consequence of the enforcement of the guarantee. So in typical situations in bank, project finance deals, the moment the bank issues calls an event of default, that's the day one when there is a chance for the pledgee to also enforce its rights under the pledge deed. But in this case, there was a particular notice period that was mentioned, and so the pledgee in this case was required to send that particular notice to the pledgor. And the day one of the enforcement in this case would be the day on which the pledgee received confirmation of the receipt of the notice. So I would also like to point out that it would be, for good office order, it would be beneficial if you're sending an email to the pledgor intimating them about the start of the enforcement. It's good to have your read receipt on, so that way you can be instantly intimated when you send the particular notice to the relevant counterparty and informing them that the pledge would now be enforced.
Thanks, Surath. And I guess many times they might say no to the red receipt. So at least you get a response that they may not have accepted, but it's delivered. So that's understandable. Very good. And quickly, what are the steps to take control of the company at the enforcement time? Like quickly, if we touch upon that.
Yeah. Next slide, please. Thank you. So basically, it's a simple process. Only if you are not a company which has investment license, For a simple trading company, what you can do is you can just, on the occurrence of the enforcement event, you can simply put a date on the relevant ancillary documents, and then you take control over the company entirely, including the management. However, in case of a company which has a business investment, I mean, an investment license from whether it's the MIC or the SEZ, you need to go through certain hoops before you can, actually effectuate the transfer of shares. So you can sign the irrevocable, you can date the irrevocable proxy and power of attorney on day one. Then you can proceed with the relevant resignation letters, etc. But you cannot sign, you cannot put the date on the share transfer form. For that, you need to mandatorily wait for the approval from the relevant investment licensor who has provided you the license to carry on business. So, because in the event that the enforcement causes the transfer of majority shares in your company, the approvals from the MIC is triggered, and but that's not the case with SEZ, because in SEZ any quantum of transfer would trigger the approval requirement. So you need to wait for SEZ approval for that. But with respect to MIC, you need to, in case the pledge results in the transfer of majority shares, then you need to wait for the MIC to approve the transfer. After that, you can stamp the the share transfer form. You can date the share transfer form and proceed with taking control of the company.
Okay, great. Thanks a lot, Surath. That's a lot of information, and I guess it does, in a way, streamlines a lot of understanding and certain nuances of the process. But with that, I'll now go to Rohan and touch upon certain regulatory sides of it and pull down aspects of the enforcement. Rohan, coming to you, what approvals are required before taking control over the said pleasure?
Thank you, Nishant. I am Rohan, and I have been working with the Myanmar office for more than 5 years now. And I will lead this discussion with respect to regulatory approvals as far as share pledge is concerned. So, going to Nishant's specific question on regulatory approval, I think this follows on from what Surath mentioned in the previous discussion. So, I mean, we have the enforcement notice which is passed and we have all these documents, but none of it can actually be effectuated if we don't get, or if the company doesn't get regulatory approvals with respect to its specific licenses that it on the basis of which it operates. So I mean, the first sort of nodal license which I can license or permit which I can talk about is the investment permit from the Myanmar Investment Commission. Now, the investment law specifies very clearly that if there's a majority ownership or control of the investor, which is the company which we are talking about that is changing, or if there's more than 50% of the assets of the investor which is being transferred, it can be through an asset sale or a share transfer. We need to take the approval of the MIC unless it's exempted. I'll come to that in due course. And that sort of is the key for this entire transfer process or enforcing the share pledge process, where we need the approval of the MIC before dating that share transfer form which was being discussed with by Surath. Yeah, and the MIC, the investment law, not only talks about share transfers, it also talks about control, where if your majority of the directors are changing, which will happen if the pledgee is actually taking control of the company, that also requires approval. So that's the main sort of approval angle which we are looking at. There's of course this company might have specific business licenses. Those licenses might have terms and conditions in the license itself, which requires approval for a share transfer. And I mean, we've sort of, in our experiences recently, we've seen that depending on the specific case itself. We've seen the Competition Commission often being involved if being asked by the MIC or otherwise to sort of have its say on proceedings. So it's always a good idea to sort of keep the Competition Commission involved. So yes, Nishant. So I mean, from an approval perspective, these are the approval framework for. Yeah.
Thank you, Rohan. And with that in mind, and one thing to note is that Competition Commission may not have till date, or have they issued the merger thresholds?
No, they haven't issued the merger thresholds yet outside of the telecom sector. So this is something which is entirely on an ad hoc basis. But again, as per recent or as per our sort of experiences, there's always a dialogue, and the Competition Commission will come back and ask for specifics if the Competition Commission feels necessary.
And say we're just talking about, say, enforcement side of it, and from a technical perspective, I know you've alluded upon that, but two questions is what triggers an approval, one, in more specific sense. And and more important question would be, are these mandatory approvals? Like, can you enforce without regulatory approvals, and yes or no consequences of non-compliance? If you have any examples, please let the audience know.
Yes, sure. Thank you, Nishant. So in terms of the trigger, it's the enforcement notice, which was spoken about by Surath. It's the enforcement notice under the share pledge, which triggers the requirement for taking the approval, because without the approval, you can't actually effectuate that the enforcement of the pledge. So that's the answer to the trigger related question. Now moving on to a mandatory requirement. Yes, this is mandatory. The approval requirement is mandatory. There's, unless it's sort of exempted, and as far as exemptions are concerned, it's actually only if it's a transfer to a related body corporate. Now, a related body corporate defined under the Myanmar Companies Law as well as the Myanmar Investment Law is basically a holding company of the corporate, a subsidiary of the corporate, or a subsidiary of a holding company of the corporate. So if it's in this chain, then the approval is not triggered. But I mean, this is not. So basically, let's just stick to, I mean, the fact that yes, an approval is required from the commission. And again, you have to check your specific licenses to see what the terms and conditions of those specific licenses are. And in terms of consequences, yes, of course, it's like the MIC has specified in very non-ambiguous terms that any non-compliance can lead to a censure of the business, a temporary suspension of the business, suspension of tax exemptions, revocation of a permit, or adding the business to a blacklist. Now, I mean, from the perspective of the pledgee, you do not take approval and you try to take control of the company. Your company itself will not be in a position to survive because it might face any of these consequences from the MIC. Apart from that, there's sort of a different angle which is also can be considered. I mean, from a criminal law perspective, the Myanmar Penal Code actually lays down several consequences if we deem this practice of taking over shares without having proper conditions or approvals in place. It can be deemed as cheating, criminal misappropriation, etc., which is, of course, I mean, subject to the court having decided on it. But there's a possibility that this can happen if you're not taking the due course of law. So I think that's another very important aspect as far as this discussion is concerned.
Good point. And for those who are not very familiar with Myanmar Penal Code, the penal provisions are drafted in such a broad manner that it can be interpreted in many ways. And as a general practice, what we have seen in Myanmar is that while this is purely a civil issue, they tend to bring in about the criminal elements and also consequently file criminal cases just to pressurize. So that's what probably Rohan was touching upon. And couple of things. I mean, thank you for that. And couple of things like, In addition to, say, change of shareholders, right? Would a regulatory approval be necessary for a change of directors? Or, and while you're talking about it, you can also probably touch upon the fact that, when must, one apply to the regulators? Like, what's a good time to do that?
Yes. So I mean, say for the shareholder change requiring an approval, a director change also requires approval. It's very clearly laid down in the Myanmar investment law, in the rules rather. And I mean, these approvals are actually sought for right after you have the enforcement event. You go to the MIC and you sort of apply for these approvals as a one-stop, one application process to have these in place. Yes, Nisha.
Great. Thanks. And what documents must you submit, to the regulators? Electric filings permitted?
Um, Electric filings, the practice of the MIC is to have everything in hand. So it's always physical filings as far as our experiences have been. And I mean, in terms of documentation, it's the application form. You write a letter explaining this entire process and what has triggered this share transfer. Because again, this is not a regular share transfer where like an M&A transfer. It's more of an enforcement. So you give the background of the pledge, you submit copies of the share pledge, and in the application letter you sort of detail what has triggered this enforcement, which leads to the share transfer form, and how that entire process is laid down. You, of course, you give the ancillary documents which Surath mentioned. You submit them to the MIC to show that you have everything in place to sort of enforce the pledge and to take control of the company.
Very clear, very clear. And importantly, I mean, can a company continue while these approvals are pending? And I mean, have you ever seen like there are conditional approvals, and say what time will it take to get those approvals?
Yes, Nishant, thank you for that. So basically, it's quite important to know this because, I mean, approvals can take a while. So the key element here is what happens to the business once the approvals are pending. And the short answer is there is no impact on the business unless your pledgor, who might be a disgruntled shareholder, goes to the court and applies for an injunction, and the court deems that injunction to be a valid application and grants the injunction. In that case, there might be certain repercussions, but from a general perspective, no, the business can carry on as it is. There is no conditional approval concept as of now that we've experienced. And in terms of timeline, this is very it's highly discretionary on the regulator, and we know that these meetings are held on a periodic basis, and depending on when the application is lodged and at what time the regulator is actually having these meetings will determine the course of the process and the timeline. But just to give a rough sort of timeline, I think 3 to 6 months is an estimate, but again, that's not something which is laid down in stone because there is no sort of exact guideline on the timeline.
Thank you. Thank you. And
Yeah.
again, like what are the typical post share transfer compliance requirements you have seen? Say we have done we've got the processes in place, and now the compliance angle kicks in.
Yes, so I think this again ties down to what Surath mentioned, which was all undated, and we have all these ancillary documents, and then we go for approval. So then now we've received the approval. What do we do first? We stamp and date the share transfer form, and then we update the shareholder register of the company. At that point, the company is effectively in the control of the pledgee. So the pledgee has taken control of the company. The company secretary will, of course, you will then cancel the old share certificates which were issued in the name of the pledger, and you will issue new share certificates to the pledgee. You will register the new shareholder and directors on the DICA. This roughly takes around a week as per present practices, and depending on the specific business of the company, you sort of register that, say if it's a MOC company, you register on the TradeNet, etc. So that's the completion of the processes as far as once you have approval and you can go ahead and take control of the company.
And any complications you could see during
Uh,
this process?
Yeah,
Um,
I think very briefly, some complications might happen if there have been past non-compliances. Say, for instance, I'll give an example where, say, you have the executed you have the executed board resolution. This resolution, I mean, there were resignation letters as well, but those directors which have resigned, etc., are not on the board and not registered on the DICA. So the records which were at the time of the share pledge versus the records which are with the DICA are different. Then DICA will raise certain questions because it won't really match with what they have in hand. And at that time, I think, again, the master key which Surath spoke about is the irrevocable proxy which you can use. So you can use that to have a board resolution, to have shareholder resolutions where you can ratify previous resolutions, give effect to new decisions, and then appoint the board, and then go back with that to the DICA, something around those
Makes
lines.
sense. Makes
Yeah.
sense. And in fact, it also chimes into the fact that what Surath alluded upon was the fact that you need to continue to monitor the updating of ancillary documents, because that's a very key element of how the securities get enforced. Thank you, Rohan. Very interesting points you have put forward, and I'm sure our audience have a lot of takeaways from that. With that, let's touch upon a bit of tax element, because that's very elemental to the whole process in itself. And for that, I will request Diber for his views. So, Diber, coming to you, again, very quickly on some macro aspects first. So, what is the stamp duty payable on share transfer form, and are there any notice requirements for IRD? What are the timelines and the documents which office should be filed with, like you would file with IRD?
Okay, thank you, Nishant. And I'm Diber. I'm the tax partner at DFDL Myanmar. So just to give a brief of what are the tax implications on the enforcement of the share. So the major consideration here is on the stamping. So for the stamping, it's on the stamping of the share transfer form. So as what Rohan mentioned, the first step of the post approval requirement would include the stamping of the share transfer form. So the stamping itself is subject to 0.1% of the value of the shares. The value of the shares, it's a little bit tricky for enforcement of shares because there is no consideration that was paid in acquiring or in enforcing the shares. So the typical issue that we encounter for this kind of arrangement is how to determine the value of the shares. So one of the aspects that we need to look at is if the value of the shares corresponds to the loan amount that is pledged, then it's possible and it is likely that the value of the loan can be considered as the value for the share transfer form or the share value per share transfer form. Now, there could be a difference in this aspect with respect to how the share transfer instrument, the share pledge instrument is defined, especially on the secured obligation. But the general approach here is it can be considered 0.1% of the loan amount. Now, the consideration for stamp duty is the stamp duty must be paid on or before the execution of the share transfer form. And if there's any delay, there could be a penalty of up to 3 times of the amount. Now, with respect to the notice period of the notice to the IRD, it's usually just a notification requirement, which is 15 days from the date of the change per MICO extract. So if there is a change of the shareholder within 15 days, it should be notified to the tax office of the company where the shares are, the Myanmar company that is affected by the share pledge. Now, an issue for the enforcement is whether there should be a capital gains tax applicable on the share pledge enforcement. From our view, there should be no capital gains tax at the time of the enforcement, simply because there is no sale, there's no exchange or transfer of the share in with consideration or with the price. So from our view, it shouldn't fall within the scope of a sale, exchange, or transfer under the Transfer of Property Act. And at the same time, because the enforcement is unilateral, it's not for if it's undertaken as an enforcement of the shares, it may not qualify under under the scope of a transaction that triggers capital gains tax. But because there are no documented rules on this in Myanmar, it may still be preferred to get a confirmation of ruling from the tax office just to get a confirmation.
Thanks, Diber. And I guess you've touched upon something very interesting, that CGT as an applicability, despite the shares changing hand, may not be applicable when we are talking about enforcement. But I presume that would be applicable when we go on the sales side, and I'll come back to you on that. But before that, sales side as in post-enforcement. But before that, just a reminder to all the audience, our Q&A is opened. Please feel free to raise questions with respect to the topic, and we'll be happy to answer. That said, let me come down to some, practical aspects of the transaction. And coming to you, Surath, could you enunciate a bit what are some considerations around sale price for companies in Myanmar, particularly keeping in mind the distressed angle, and also at the same time, if you could touch upon some what kinds of examples of reps and warranties in distressed asset sales. Let's be a bit quick about it, because we have a limited time now.
Yeah. Okay. Thanks, Nishant. So basically, there are a few key considerations which are instrumental in setting the purchase price. So number one, I think it's seller's motivation, because in the sample case, the seller was highly motivated to take possession of the shares quickly and exit the market. So that also has a bearing on the purchase price, etc. So now as a matter of market practice, what we are seeing is purchase prices being negotiated at substantially discounted rates compared to the book value, possibly in double digits, considering the given market situation. So what we can gather from it is that purchasers are, they want to buy cheap and hold on to the company, and with the hopes that when the market will look up, the segment will rise and they'll be able to draw profits out of it. Now, interestingly, although it's not related to this topic, we are also seeing some, similar discounts and haircuts that offshore lenders are taking with respect to loans, for example. Like double-digit haircuts that offshore lenders are taking with respect to assigning those loans to some third parties, and then exiting the Myanmar market, probably stimulated by certain reputational concerns from staying for long and providing the loans.
Thank you. And what about some of the reps and warranties, Surath? Can we quickly move on that?
So it's pretty standard, and it's a function of the it's a result of the due diligence that is carried out by the buyer. So typically, in relation to corporate matters, the sellers would be asked to provide representations relating to the fact that they own the shares and the shares are not encumbered in any way. The shares are paid up. They'll also accept as disclosed. Obviously, there'll be a disclosure list which will actually provide the actual fact situation that applies to the sale. With respect to financial statements, for example, it would say that it's fairly, the financial statements shown are fairly accurate and represent the current status of the company, and the fact that all the dues have been paid off, etc., except again as disclosed. There are no pending or threatened litigation. Now, with respect to litigation searches, it's a bit complicated, as the audience already is aware. So there has to be pretty strong representations and warranties, and also covenants, etc., as well as certain, periodic undertakings or information covenants to be provided by the seller from time to time till the completion. So, yeah, these are some of the typical representations and warranties that we usually observe, or we have been observing of late, with respect to distressed M&A.
Yeah. Thanks, Surath. I mean, just to enunciate that a bit as I take away from your statement is the fact that there is a bit of flexibility, depends on the nature of sale. Is it on an as is whereas basis vis-a-vis, is it with certain conditions embedded with the sale? And then the reps and warranties we discussed actually comes in. So there can be two models to it, and obviously it makes total sense. Diber, again, I'm mindful of time and apologies. I'm trying to rush this a bit because I want to have some time for Q&A if applicable. So quickly, without much ado, on the CGT side of issues of the sales side, when you are selling this as after enforcement, there could be certain complications because I understand that is when you would be required to pay the CGT, right? And there could be different values as the value of enforcement versus the book value of the shares. And quickly, when you're talking about it, could you also factor compliance side of it briefly regarding the requirements to register at the tax office and general timeline?
Okay, thank you, Nishant. So for this sale part where the enforced shares are already transferred or for sale, so there could be a capital gains tax requirement under this arrangement. Now, the issue that we see for this is on the consideration and the cost component of the pledge of the enforced shares. Because from the point of view of the IRD, the calculation of a capital gains for shares is the consideration used per SPA and less the cost of the shares per MICO. So the cost of the shares per MICO is the book value of the shares, which is the amount of the value as declared in the MICO, and it doesn't necessarily mean that it is the amount paid by the buyer or by the amount paid. Now, an area for consideration here, because there are no clear guidance under the rule, is to get a confirmation from the IRD, because whether the IRD would consider any loaned amount as part of the cost of the shares, it's subject to a consideration of the IRD. But if the IRD has not provided a clarity of what is considered a deductible cost for capital gain, they would generally consider whatever the amount of the cost per MICO as the cost or acquisition cost of the share. So that could create an implied gain even if the company is selling it on a distressed situation. So that is one of the key areas that we need to, that we want to highlight, that if you are considering this approach, it's suggested to get a confirmation from the IRD on what are the actual deductible costs arising on an enforcement of a share pledge. Now, another aspect for the CGT is registration of a non-resident. So if the seller is a non-resident, so they need to register for CGT. Now, there is also a stamp duty aspect, which is similar to the earlier one, which is 0.1% of the amount of the value of the shares sold. And then there is also an IRD notification.
Thank you, Diber. So there are a couple of compliance side, even in situations of sale that has to register, particularly with IRD from CGT perspective, and that's a good takeaway. Let me come back to Rohan and Rohan, quickly, being mindful of time again. A couple of questions to you. I'll divide them into two parts. The first being, whose approval do you need to sell the business? Any municipal level licenses or similar other regulatory approvals? And do you need FESC approval to repatriate the purchase amount, say the money is being paid in Myanmar?
Very quickly, Nishant, mindful of time. So, yes, short answer is the same as I discussed previously. In a distress sale situation, considering more than 50% sale, we need approval from the MIC, and depending on the specific business of the company, we need the approval from the nodal authorities which deal with that specific business. The documentation is as was discussed. Again, you have the application form, you have all the ancillary documents, you have the resolutions, all of that submitted in copy in person to the MIC, and in parallel to the other authorities as well, which deal with the business. And in terms of your second question on the FESC approval, the very short answer to that is yes. Based on recent notifications from the CBM, any transfers offshore of funds will require an approval from the FESC. The timeline may vary between 1 to 3 months, but this is a requirement nowadays. Yeah.
Thank you. And another quick question would be, could you maybe take us through some of the post-compliance, steps, and what we could go to the next slide, please.
Yeah. Yes, sure. I think this is again very similar. And just to close off all the dots, basically, it's again, you stamp and date the share transfer form after the approval. You update the shareholder registry, you issue new shares, you cancel the old ones, you register the new shareholders and directors with the DICA, you notify the tax authorities as Diber mentioned, and then you, depending on the business, you update the TradeNet account, or you make any specific sort of reporting to the specific authorities. And that would sort of be the post-sale compliance steps to make sure that the transferee has now got the business. Yeah.
And I believe there have been some instances where certain investigations from financial investigation units have happened to a certain the source of the purchase price, and that often happens in between, say, the approvals and closing. So, have you seen something like that?
Yes, Nishant, this is sort of a recent trend that we've seen. So it's very mindful for businesses and companies to sort of ensure that these compliances are taken care of, and the sourcing of funds are always clean. Yeah.
Good. Thank you. So, it was great listening to you all, and we have a couple of questions, so which I believe I would bounce it off and let the panel decide who would want to take it. So there is a question from Henry. Hi, Henry. Henry is in power industry and an expert there. Do you need to get the approval from the focus ministry apart from MIC before the share transfer takes place, or we can inform or approval from the focus ministry and Myanmar Investment Commission? So basically saying, I understand you did touch upon that, Rohan, but there's no harm just quickly enunciating that once again.
Yes, sure. So I think it has to be a parallel application. It's not like if the MIC approves, automatically the other authorities or the other focus ministry has approved. So we've always taken the stance that these are parallel applications to the specific regulatory authorities, and they discuss internally. So it's a very common practice that approvals will actually come hand in hand. And if the MIC approves first, you'll have the focus ministry approving, say, after a week or something like that. But yeah, that's the standard approach which is taken.
Great. And we have another question. I believe it's a bit of a googly. If you play cricket, you understand what's a googly. The question is, which form do we need to use and apply for share pledge at MICO DICA? So I believe the question is about creation of share pledge and whether there is a compliance necessary per se that would trigger filing at MICO. Surath, you want to take it?
Yeah, so I already answered on the chat. So it's basically Form H1 that needs to be filed with DICA. The form is available online, and it's typically the form which is used to create security, which is used to register the share pledge with DICA. So yeah.
Okay. Another element which I believe applies here is that the shares are not the asset of the company. Shares are assets of the shareholders. So in that case, if the shareholder is an individual, then there is no filing necessary. It's just a share pledge. But as a good office order, people still go ahead and file that under the registry of the company just for the record's sake, but it has no legal necessity or relevance. Another relevant question which is asked is if we make an amendment or modification on share pledge, what kind of form should be submitted? I guess I'll rather take it myself. I guess it's the same kind of form, whether it's necessary you being a shareholder, being an individual, or you're a shareholder, which is a company, and then according to the modifications will have to be refiled. With that, I guess we're going to close the Q&A session, and apologies to have rushed a bit at the end because it's such a vast topic and we had to cover a lot. With that, I thank my panelists to have shared their views and educated the audience on the subject. And I wholeheartedly thank our audience to have taken out time from their busy schedule and to have joined us and listened to this important topic. So if you have any further follow-up questions, please feel free to reach out to any of the panelists here. You can find us at DFDL's website, and also our emails are mentioned below our name on the screen. Take a screenshot of that. And thank you so much. Thank you.
Thank you. Bye bye.